Hello, everyone, and thanks for joining us for our session on Building the Research, a Blueprint for Evaluation. I'm here to introduce our featured speaker, Dr. Nancy Levine, and our panelists, and give you a roadmap for today's session. Nancy Levine was appointed by President Biden as Director of the National Institute of Justice in March of 2022. As head of NIJ, Dr. Levine leads the Justice Department's Research, Technology, and Evaluation Agency, overseeing a wide array of social science research projects, technology initiatives, and forensic activities focused on improving public safety and ensuring the fairness and effectiveness of the justice system. Dr. Levine is a nationally recognized criminal justice policy researcher whose expertise ranges from policing and corrections reform to reentry, criminal justice technologies, and evidence-based criminal justice practices. Dr. Levine's overview will allow our panelists to then delve into the community court model's adaptability. Its inherent localized, flexible approach has allowed community courts to flourish in multiple settings beyond courthouses, including neighborhood-based courts, local libraries, community centers, and even mobile, as well as serving a variety of issues and populations. We will hear from the following panelists: Diane Whaley, Public Defense Coordinator and Community Court Executive of the Olympia Community Court in Olympia, Washington. Matthew Willis, Manager of Evidence and Impact of the Neighbourhood Justice Centre, Magistrate's Court of Victoria in Australia. And Deloris Vaughn, Justice, Equity, Diversity, and Inclusion Evaluation Consultant based in New Haven, Connecticut. These presentations are pre-recorded. Afterwards, Nancy will return live, make some reflections, and take questions from the audience. I will be moderating those questions from the chat and passing them along to Nancy. Diane Whaley from Olympia Community Court is also here with us today, though not on screen, and you can pose questions to her using the chat feature. Finally, I want to mention that tied to this session is the publication that this session is named after that can help guide community courts through developing this research base, which you can access at the CVent Attendee Hub, as well as the Center for Court Innovation's website. Thanks again for tuning in, and I'll turn it over to Dr. Nancy Levine.
Well, greetings, everyone, and thank you so much, Natalie, for that warm introduction. I'm Nancy La Vigne, and I am delighted to be sharing with you some of my own experiences and my goals and priorities for the National Institute of Justice that remarkably align very well with the three speakers that you'll be hearing from later today. I was appointed as Director of the National Institute of Justice by President Biden in March of this year, and I started in May. And I couldn't be more delighted to lead this exceptional agency. It's actually an agency I know very well because my longer version of my bio would share with you the fact that I actually worked at the National Institute of Justice some 25 years ago. It was in a different capacity, of course, than coming to lead it as director. And I've done much in between that time, but some things have remained the same. And one is that the NIJ is really an exceptional organization, populated by some amazing experts. And we've always had a mission of leading science through the awards of grants and contracts that support knowledge development across a whole host of topics in the criminal justice space. Ones that are focused on public safety, as well as ones focused on the criminal justice system, justice efficiencies, and we cover issues that pertain to policing and courts and prosecution and corrections, as well as forensics and investigative sciences, technologies and technology standards. The sky's the limit. There's very few topics that we don't address at the Institute. And another thing that has never changed at NIJ is that the research that we support is designed to build evidence that can improve practices on the ground, promote public safety, and promote more equity in the criminal justice system. So, for all those reasons, it was the thrill of a lifetime to be tapped to come and lead NIJ as its director. And I have had a fair amount of research experience myself, and that helped guide me in thinking about what I see as priorities for the Institute during my tenure. And that those priorities are really born of experiences in doing research the way I was trained to do it in my doctoral program, and more importantly, research that I've come to learn is really the right way to do it. And that I learned through experience on the ground, through trial and error, and through taking time to really reflect on what is the purpose of research and how can we do it in a way that really promotes the goals that we are hoping to achieve through research. And that leads into five key priorities I have as director. The one is through supporting grants for research, as well as through having the bully pulpit through opportunities to speak to you today and other speaking opportunities I have in my role, is to promote what I'm calling inclusive research. I absolutely did not invent that term, and it's a term that is being used more often by many, including one of our presenters today. But for me, inclusive research means taking the time to ensure that no matter what the topic or the methodology is, that the researchers take time to learn from the people who are closest to the issue or problem that's being studied. Now, in my mind, inclusive research really can span a continuum. So, on one end of the continuum, on the most extreme end, that's called community based participatory research. And that means that you can barely have a research topic identified without engaging the people closest to that topic. Is this the right research question that we should be exploring? If not, why not? And then every step of that research process involves partnership, equal partnership in conducting the research, the methodology, collecting the data, analyzing the data, interpreting the data, producing the findings, identifying how those findings have implications for policy and practice. So that's on one extreme end of the continuum. And I definitely want to see NIJ support more research in that realm, as well as the field at large, regardless of where the research funding comes from. But I also recognize that there's a lot of different research questions that might demand different types of methodologies. But even if you look at the far end of that continuum on the other side, highly quantitative research, maybe it's a randomized controlled trial, I still firmly believe that those researchers can also engage in inclusive research practices. So you can decide that you're going to conduct a survey to learn something new. One way to be more inclusive about that is to engage the people you're trying to survey in developing the survey questions. Right? Now, we as researchers often don't do that. Instead, we look to past research. What's the latest journal article that uses a survey instrument that seems to be getting at the same questions that we want to explore? And then how do we want to adapt those questions? Now this is a very different process when researchers take the time to really consult the people that they're surveying. Even again, at that far end of the continuum, even if it's highly quantitative, it's using pre existing administrative data, it doesn't have a qualitative component to it at all, there's still an opportunity to bring the findings to the people that are affected by the issue or problem. It could be practitioners, prosecutors, it could be um, survivors of violent crime, you name it. Bring those findings back and say, here's what we found. How does that align with your own experiences? And that's what I would call ground truthing, which I think is extremely important as researchers. And then what do these findings mean for changes in policies and practices? That's researchers shouldn't come up with those answers on their own. In fact, they don't do a particularly good job of it, in my experience. And peer reviewing journal articles, and at the end, it's like the policy implications section is just one little paragraph. Researchers aren't necessarily trained to identify those implications. So that was a long way of saying that inclusive research is a number one priority for me as director of NIJ. And please expect to be seeing more on that in the future. Another priority for me is closely aligned to inclusive research, and that is approaching research through what I would call an equity lens. It could be a racial equity lens or an equity lens regarding gender, sexual identity, religion, philosophy, but really thinking about research through an equity lens is it's essential for any research that involves the justice system because we know that the criminal justice system has a long history of biases and institutional racism and structural inequalities that lead people to be engaged in the criminal justice system. There's so much that's baked into the system that if we're not intentional about looking at those issues of equity, we're going to not produce equitable research or equitable research findings. Now, NIJ has long invested in research that identifies inequalities, identifies racial inequities in particular, and also identifies ways that we can reduce those inequities and how effective those strategies are. And that will absolutely continue under my leadership. But I would argue that it doesn't matter what the topic, there is absolutely an equity lens that we should be applying to each and every topic that is explored. A third priority is around promoting what I would call multidisciplinary research or multidisciplinary research teams, right? So I'm trained as a sociologist. I have a degree in criminal justice. There's a very applied form of sociology specific to the study of the criminal justice system and issues around it. And that's a specific way that I've learned to approach research. But there's all these other lenses and perspectives and disciplines that we can benefit from. And I would argue that any one of them on their own is probably good, but not sufficient. But imagine what it would be like if we teamed up an economist with a social work researcher, or a psychologist with a public health researcher, or even multi research teams that cover all four of those disciplines. I think there's a lot we can learn from partnering so that we can bring different perspectives and different methodologies to the fore. Now, another priority I have has to do with what I call implementation science. I didn't come up with that phrase. It's well known in certain circles. And past NIJ directors have often talked about the importance of promoting rigorous evaluations, often lifting up what's known as the gold standard of evaluation, which is the randomized controlled trial. That's an experimental design, and and that's all well and good. But there's some research questions that cannot be answered through experimental designs. And I would argue even more importantly, if we focus too much on the impact evaluation methodology at the expense of documenting the implementation portion of the evaluation, then we're really losing out on critical information. I mean, community courts is a great example. We can look at the impact of community courts on outcomes for the people who are engaged in them. But if we don't know whether the community court model was implemented with fidelity, then any impact evaluation, no matter how rigorous, is not going to inform us much. Like, what if the impact evaluation, highly rigorous experimental design, finds that the community court didn't yield the impacts that we desire? Does that mean that community courts don't work? We don't know the answer to that because we don't know whether the court reached the populations they desired to reach, delivered the services, were the services aligned with the needs of each client. We don't know that. So that's why implementation science is a big priority for me as director of NIJ. And finally, I want to focus on what I'm calling evidence to action. Now, NIJ has a long history of doing, I think, an exceptional job in translating academic research for a wide array of audiences, be they practitioners or policymakers or even the general public. And that has continued to improve over the years. But what we don't know well is even with that very strong translation component, is that leading to change on the ground? Is that leading to changes in practice? We just don't know. We don't know if it's leading to practice, and we don't know what the right methods and mechanisms are to ensure that it does. So, our evidence to action initiative will be calling the research way outside of the criminal justice and related disciplines to find out what is the science behind what leads people to learn about evidence and what leads them to apply evidence. And that's in marketing, that's in communications, it might be in the field of medicine or public health. There's a lot we can learn about what leads people to learn about evidence and to want to really implement it intentionally and accurately. So we'll be studying that knowledge base. We'll also be convening various practitioners and end users to better understand what leads them to want to learn about research, want to learn about evidence, and what leads them to actually implement that evidence with fidelity. So, in closing, I really appreciate the opportunity as a relatively new director to be able to share my vision and priorities for the Institute. I'm eager to learn more from our panelists today. You're up for a tremendous lineup of three experts in the field. And then I look forward to joining you afterwards to take any questions you may have. Thank you.
My name is Diane Whaley. I am the Community Court Executive and Public Defense Coordinator for the City of Olympia. I'm going to speak to you today about what it looked like for myself and our interdisciplinary team to use data and research from the beginning of planning and building the Olympia Community Court. Olympia Community Court is located in Olympia, Washington, the state capital, and serves the entire city of Olympia. It launched in 2016, operates every Wednesday from 8 to 12 at the Lee Creighton Justice Center, and is currently operating under a hybrid model using Zoom since spring of 2020. A provider building that previously housed social service providers in person is now currently used to allow participants to walk in and connect on Zoom if needed. Participants currently connect with their attorney, case manager, and social service providers in breakout rooms on Zoom during court. Our court serves misdemeanor and gross misdemeanor crimes filed in Olympia Municipal Court, and most cases are primarily theft in the third degree. Eligibility is based on a written policy by crime type, which targets low-level offenses. Participants are informed of eligibility early on at arraignment by their public defender and complete a CCAT risk needs assessment if interested in opting in to primarily pinpoint social service needs. Our community partners appear in court for an individualized schedule by agency as memorialized in an MOU. Our chosen partners cover every niche needed for success, including housing, mental health, drug and alcohol, medication-assisted treatment, employment, basic needs, healthcare, social services, education, legal services, family services, transportation, and youth services. The core planning team in our court meets every Tuesday to prepare for court and includes the judge, prosecutor, public defender, community court executive, court administrator, case manager, restorative justice coordinator, and probation. Our latest focus is the development of a restorative justice program called Community Circles. We were interested in launching a community court in Olympia due to the historical disconnect between the Olympia community and the criminal justice system. Olympia is a small and progressive city with a close-knit community. However, there was a recognized need for improved communication and collaboration between the court, service providers, and the community to address the low-level offenses coming through the Olympia Municipal Court. Further, resources in Olympia and in the surrounding county are robust, but spread out, making it difficult to connect with social service providers for some with transportation barriers. A community court meant an immediate on-site helping hand under one roof from the inception of the criminal process, i.e. arraignment. Last, with growing public safety concerns in the downtown core, coupled with the passing of the 2015 indigent standards by the Washington State Supreme Court, which limits public defenders' caseloads, the momentum to reduce recidivism was in full swing, with hopes to decrease the number of cases filed. Given each of these factors, Olympia was looking for a non-traditional approach with tailored solutions for each individual with an open case to make them most successful. In researching and planning Olympia's community court back in 2015, we immediately began looking at criminal court data, which I'll circle back to in a minute. We completed a formal needs assessment with the Center for Court Innovation, which included stakeholder interviews and focus groups. This gave us a lens on issues that were of most concern in the community, resources needed, and contacts for us to follow up on as potential providers. During this process, some members of the core planning team made several visits to other community courts to observe the process as well. Stakeholders expressed the increasing quality of life issues observed over the past decade in the downtown core, including drug and alcohol use, mental health issues, and homelessness. They also noted a heightened distrust between the community and the justice system, in particular the police department. Further, we reviewed existing data that had already been gathered by the city, including a community survey on public safety as well as police statistics on call types. Overall, the research results we obtained during the needs assessment process gave a clear lens, confirming that we were on the right path for an alternative non-traditional approach and gave us additional guidance for our focus. The first criminal court data that we explored were the number of low-level offenses filed and assigned to the public defenders in Olympia Municipal Court. In my dual role as the public defense coordinator, I tracked all of the crime types assigned to the public defenders in an Excel spreadsheet over a 3-month time period and saw that 1/3 of all cases assigned to public defenders were low-level offenses. The estimated number of cases that would be eligible fell around 350 cases per year. However, FTA rates and warrants in time would impact the number of opt-ins. The initial community court policy as written allowed for 14 eligible crime types and primarily used a deferred sentence structure for case resolution, which meant an initial plea of guilt, then plea withdrawn, and dismissal upon successful graduation. Prior criminal history excluded eligibility on theft cases in the first draft of the policy. Once our community court got off ground in January of 2016, we reviewed the data in a running Excel spreadsheet, which tracked all cases coming through. With driving while license suspended in the 3rd degree coming in as our top crime type opting in, we knew that some changes needed to take place to shift and allow more theft in the 3rd degree cases to opt in, and that the policy at the time was too restrictive. Thus, based on this proactive data review, the community court team struck a provision which excluded thefts based on prior criminal history. To expand that category, and theft in the 3rd degree shifted to our number 1 crime type and has remained so to this day. In 2019 and 2022, respectively, the policy was again updated and expanded eligible crime types eventually to 28 and allowed for cases to resolve via stipulated orders of continuance, which are contracts to continue and dismiss short of a conviction, which is much more favorable to our participants for housing and employment purposes. A large incentive for expanding the eligible to crime types was to attempt to shift more cases from the traditional system to community court. This attempt to shift more cases is something that we continue to track and monitor. Another important way that we utilize data in building our community court was for the purpose of engaging partners and obtaining resources to respond to the needs being seen by the community served by the court. In our planning phase in 2015, we utilized materials from other community court jurisdictions to entice local social service providers to participate in our court. In finding and vetting our providers, a lot of research took place on the internet and by then interviewing them. Once a decision was made that a provider was the right fit for our court, the next step was the MOU. In engaging a provider to sign an MOU, the conversations typically focused on the fact that those coming through the system were mutual clients. We really stressed the fact that by having all providers under one roof in a one-stop shop, there was a higher chance for success of the individual to be stabilized and self-sufficient, with the long-term goal of increasing public safety in the community. To keep our providers engaged once committed, we have used multiple methods. First, we have used on-site provider informational sessions before court to connect providers to each other and learn about resources offered. Second, we have used a dual data tracking method to track how many participants connected to each provider. On the provider side, we kept binders in the provider building that had a running tracking sheet in which the provider wrote down the name of the participant they met with, the date, and a short description as to the nature of the conversation. On the court side, all links are recorded in a small sheet, then transferred to an ongoing master Excel spreadsheet. Third, with the data collected in our master Excel spreadsheet, we annually analyze and share the percentage of participants that connected over time with each provider to show their value. Last, by sharing the court's success through statistics such as graduation numbers and recidivism rates, providers get a clear picture as to what they are contributing to. Despite great effort, Olympia has an increasing houseless population, which accompanies with it problematic drug and alcohol use and mental health issues. We have current resources, but they are limited. In reviewing the community court data over time, we can see that our #1 highest used social service provider links during court included both housing and mental health at 59%. #2 was drug and alcohol at 54%. With each of these providers a hot seat on community court days, we knew we needed to make some adjustments focused on these areas to increase capacity and seek additional resources for housing. With one part-time case manager, there was limited time to navigate community resources. As a recipient of the Bureau of Justice Assistance's 2020 National Community Courts Site-Based and Training and Technical Assistance Initiative Enhancement Award, we were able to add an additional drug and alcohol and mental health provider so that more people could be served on any given community court day and beyond. And we added a medication-assisted treatment provider, along with training resources on that topic. In addition, we increased our case manager from part-time to full-time and added a second part-time housing case manager. The increase in case management was also supported by data, given that we were looking to decrease failure to appear rates of our participants at arraignment and post-opt-in. The data showed that 2/3 of our potential opt-ins were not showing for arraignment, and some adjustments needed to be made to engage potential participants early on. So to shift gears to the publication, Building the Research Base, an evaluation blueprint for community courts. It is a fantastic resource. As a founder and part of the original planning team for Olympia's community court, finding data sets to attempt to prove a community court success to potential stakeholders and funders can be challenging. Community courts are unique in that they commonly impact individual and community life beyond simple case outcomes, just as this article describes. I would often find myself making statements to stakeholders along the lines of, set numbers aside and imagine the impact we can have on changing each life, which also has its own picture of success. The blueprint of 7 guiding principles within this article can be tailored to fit any individual jurisdiction to develop a success story that is most fitting. To share a few sample performance measures that we track each Wednesday, we use a condensed Excel data sheet to capture data for that specific community court day, specifically social service links. That data is then transferred to a larger master Excel spreadsheet that has all data from community court inception. Each week, data is entered into the master sheet from the arraignment calendar as well, which has specific cases identified by the prosecutor as to community court eligibility. The primary data we track are crime type, data violation, demographics such as ethnicity, age, gender, and education level, whether a defendant opted in or declined, the opt-in date, graduation date, revocations, and conditions completed such as work crew days, community service hours, social service links, and completion of a letter of insight and its topic. Currently, our running Excel spreadsheet is very data rich. However, interpreting yearly totals can be challenging given the current Excel spreadsheet setup. In my position, I hand count a lot of data, which is only possible because we're a small jurisdiction. Moving forward, it would be more ideal to have a system set up with tabs by year for quick reference, or even better, having a fully electronic data management system. Several examples of principles we use from the article include principle number 4, client accountability. Each year we do calculate and share community restitution mandates by using a formula using work crew and community service hours times minimum wage rates. This gives us a dollar value of labor invested in the community. Principle 7, collaboration. We do track and share the number of providers offering services to participants. For example, we grew from 4 providers in 2016 to 19 plus providers in 2022. We further track the types of services offered, utilize MOUs to lay out expectations for information sharing for each provider. We gather input from each provider at the conclusion of each community court day in writing, and our case manager collects weekly updates from our drug and alcohol and mental health service providers. We have also made adjustments in our referral process along the way by adding an additional drug and alcohol and mental health provider and medication-assisted treatment services to make sure we have the immediacy of availability for these services each week. Last, I'd like to share how we use data to report out on our operations. For this purpose, aggregate data can be used in a number of different ways, whether it's an update to City Council, an attempt to convince a stakeholder to join community court or remain a contributor, or for a simple informative presentation to a specific organization or the public. Sharing aggregate data is imperative for public trust and accountability. The type of data that is chosen has to make sense for your jurisdiction. In Olympia, we share a number of data sets each year, including the number of participants and graduates, the number of social services links made since 2016, the percentage of links made by participants with each social service agency during community court as delineated by type of service and needs served, the total value of community service labor in the community, the recidivism rate of graduates, and the top 3 crime types that opt in. Finally, we share community court graduate survey results, which are broken down by category and given percentage totals for their outcome, and have the goal of capturing the participants' perception of their experience going through the process and whether they feel justice was administered fairly. In other words, this is a procedural justice survey. Beyond the data, we commonly pick a few success stories about our graduates to humanize our outcomes. For some presentations, we invite graduates to appear and tell their story. Hearing firsthand information from someone who went through the process can be incredibly impactful, persuasive, and moving. It has been a pleasure sharing with you how Olympia Community Court has used research and data over time to make our court as successful as possible. I wish you all the best of luck in developing your own research and data story as well.
Hi, I'm Matthew Willis, Manager of Impact and Evidence at the Neighbourhood Justice Centre, or NJC, in Collingwood, an inner city suburb of Melbourne in the Australian state of Victoria. I've been with the NJC since January of 2020, when I had the opportunity to move down to Melbourne, and just really fortunately this position at the NJC came up. I'd been aware of the NJC's work through some previous work with the Australian Institute of Criminology, and was just so impressed and so moved by the community justice model that it's just a fantastic opportunity to start here. And as I've said to some people before, the day I started working at the NJC, I think was the day I first realised what it really was that I wanted to do when I grow up. So it's a great place to work. It was established in 2007 as Australia's first community justice centre. So it's part of the Magistrate's Court of Victoria and hears criminal matters for adults and children, as well as applications for protection and intervention orders and victims of crime assistance matters. The NJC has an integrated client services team that provides a one-stop shop for holistic advice and assessment services to the court, together with case management from 19 agencies that are co-located and working in partnership on site. We also have legal services and a community correctional services office on site, as well as units like our program innovation team. Importantly, access to our services is not time limited, and services are available to all residents of the City of Yarra, regardless of whether they have a court matter. So at the NJC, we have two main electronic databases we draw on for evaluation and research data, as well as for strategic planning and operational management. So CourtLink is the Magistrate's Court of Victoria's case management system that was implemented back in 1987. It's used by the Magistrates Court and Children's Court staff across the state in 53 court locations. It provides access to case-based data on the full range of matters heard by these courts and is used to manage the progress of matters through the system. So the court is currently going through a major change process and introducing a new case management system to replace CourtLink. The new system has just been implemented for civil cases, with criminal cases to follow. Our other main system is TrackCare, which is an information system developed initially for healthcare providers, which the NJC uses in managing its client services. So through working with the software provider, the NJC has been able to adapt TrackCare to work effectively in a therapeutic justice environment, supporting the exchange of information between the court, registry and client services. So TrackCare provides information on important indicators like referrals and episodes of care across the many services provided on site at the NJC, and allows us to drill down into which specific services are being provided at an individual level. As well as CourtLink and TrackCare, the NJC draws for its evaluations on administrative data collected by justice system partners, particularly Victoria Police and Corrections Victoria, and also small databases that we've set up for specific programs. So I just wanted to talk now just a little bit about some of the special interest groups within the community that the NJC works with. Australia's post-colonisation history has had many long-term impacts on our Indigenous or First Nations people. These have included the forced removal of Aboriginal children from their families in what has become known as the stolen generation, and has led to deep distrust of the justice system. The area of Collingwood where the NJC is located has long been an important meeting place for Aboriginal people and has become a focal point for members of the stolen generation. While our jurisdiction is focused on residents of the City of Yarra, it extends to Aboriginal people who live outside Yarra but have close connections to the area. The NJC employs a specialist Aboriginal justice worker and in partnership with the local community has developed Aboriginal hearing days to address concerns about low attendance rates of Aboriginal people at court and a lack of engagement with our services. So these hearings are run monthly and are attended by a range of Aboriginal support services and by the Victorian Aboriginal Legal Service. Overall, the City of Yarra is a culturally diverse community of just under 100,000 people, with 29% of its residents born overseas, many of them arriving in Australia as refugees. Some recent research we did with the University of Melbourne on modelling the changing demographics of offending and disadvantage in the city highlighted a widening divide within the city where we have both areas of rising socioeconomic advantage alongside some of the most marked socioeconomic disadvantage in the state. So the NJC responds to this diversity in many ways, including engagement with representative groups, the establishment of a community advisor panel, and the inclusion of community voices in its evaluations. We use action research approaches to capture these diverse perspectives, such as through client satisfaction surveys, and through our current work developing new indicators of social well-being and the impact that the NJC has on those. I just want to talk a little bit too about some past evaluations we've done and the importance of those. So firstly, past evaluations have been really important for ongoing funding of the NJC. We were established with pilot funding and were comprehensively evaluated back in 2009 to assess the effectiveness and value of the NJC model. The evaluation demonstrated the contribution of the NJC to reducing crime in the City of Yarra, achieving reduced recidivism and delivering improved completion of community corrections orders. It showed strong evidence of higher levels of confidence and satisfaction by justice system users, And it showed that the NJC model led to more direct involvement by defenders, applicants and respondents in court proceedings. The evaluation also demonstrated the extent of community engagement and participation fostered by the NJC and improvements in community safety that resulted from our crime prevention and community development projects. The evaluation included a cost-benefit analysis that showed a range of benefits with a cost-benefit ratio of over 2 to 1 in the longer term. Another evaluation by Professor Stuart Ross of the University of Melbourne that was published in 2015 focused on issues around measuring and attributing outcomes for a community justice program. It looked at the fall in crime rates in the City of Yarra during the first 5 years of the NJC's operations. The study noted that while crime rates generally fell across Melbourne and for some crime types internationally, over this period, the falls in Yarra were higher than in comparable areas within Melbourne. Now, noting some of the challenges in attributing widespread changes in crime rates, Professor Ross noted that there was no clear reason why the falls in Yarra should be higher than the other comparable areas, and therefore, to quote him, one is left with the conclusion that the observed changes in crime rates are what would be desired from an effective community court in Yarra, without being able to say definitively that they are directly caused by the activities of the NJC. In this study, Professor Ross also looked at recidivism outcomes, again finding that the number of NJC clients with a new proven offence within 2 years was 33% compared with 44% in the comparison group, which was a highly statistically different outcome. He found that the NJC had a significantly lower rate of unsuccessful community correction orders than comparisons, particularly for higher risk and moderate cases. In his conclusions, Professor Ross noted the importance of including in community justice evaluations indicators such as victim satisfaction with the justice system and outcomes such as offenders reconciling with their family, finding stable accommodation or employment, or receiving treatment for mental health or substance abuse problems. He said, and I quote, "We need to look beyond the conventional evaluation outcomes of crime rates, order compliance and recidivism, and ask, how can we incorporate these broader sets of questions about changes in the quality of life of offenders, victims and communities in ways that demonstrate the contribution that community courts can make?" As well as these major evaluations, the NJC has conducted or procured evaluations of many of its innovative justice programs and pilots, and has conducted client satisfaction surveys on 4 occasions, most recently this year. All of this work has been hugely valuable in informing funding decisions, assessing the utility of and helping to improve our many programs, and supporting our strategic planning processes and business intelligence reporting. The learnings from these evaluations are also reflected in the NJC's comprehensive and innovative monitoring, evaluation and learning framework, which really aims to go beyond some of those traditional measures and pick up the kinds of things that I know are reflected in the CCI's blueprint and the kinds of things that Professor Ross was talking about, where we measure impacts more directly on the people in the community and aim to assess how we affect the community at a community level and across the whole structure of the community. So I just wanted to touch on just a little bit of advice for those who might not have done a formal evaluation within their jurisdiction and are looking at doing that. For jurisdictions who have not had formal evaluations, I would suggest undertaking an exercise to clearly articulate the outcomes that you're seeking from your court's work. This might be using an approach such as a program logic model for each of your main business activities. You can then use this model to develop an evaluation framework with a set of evaluation questions focused on what you want to know about the court's processes and impacts and what your key stakeholders want and need to know. Consult with internal and external stakeholders to determine the metrics that will be used to identify the impacts and the data used to measure them. Having this framework will then help you assess whether you have the data you need to inform the evaluation or whether you need to undertake targeted data collection activities. You might even need to establish new data systems to make sure you can measure what you need to. If you're starting to develop a new program, make sure that you build evaluation into the program from the beginning. Build in the time and the resources and funding, and build in a framework to make sure you're capturing that data and can evaluate the program as you go along and at the end. Connect with people who have experience in designing and conducting evaluations if you don't have that expertise in-house. Draw on the wide range of sources and networks that can help you identify and overcome some of the challenges and barriers you might face. Plan for the fact that a major evaluation will usually take quite a bit of time and money. You'll need to engage an external evaluator and work closely with them to make sure they understand the community court approach and the activities that you want to evaluate. Thank you for allowing me the time to speak with you. It's a great honour to be able to, and it's a great honour to be able to work in a community justice environment and to be able to work on developing innovative evaluation approaches that are aiming to get to the heart of what community justice is all about. So thank you for taking the time to listen, and best wishes for the rest of the conference.
Good afternoon. My name is Deloris Vaughn, and I am delighted to contribute to the discussion today. I have worked in the field of evaluation for nearly 30 years, focusing primarily on evaluation capacity building. And I've worked in areas of education, criminal justice, and community engagement, just to name a few. I was invited to be a part of this session because I have the privilege of participating in the Community Courts Roundtable for developing an evaluation framework in 2019. That meeting was very robust and highly productive. It ultimately resulted in the creation of a blueprint for evaluating community courts. And it is based on that work that I want to kind of build on what I want to talk about with you today. And the subject is near and dear to my heart, and that's centering equity in evaluation, particularly as it pertains to what it means to use an equity lens in evaluation practice. As you may know, equity has been linked with various words that are highly charged in some arenas: race, gender, economics, etc. And over the last few years, the terms equity lens and racial equity lens have gotten a lot of traction within the public and private sectors and across disciplines, including evaluation. So let me get into what it means to me to apply an equity lens in evaluation. To me, it means evaluators or anyone doing evaluative work has to first conduct a self-examination or self-assessment of their core beliefs and values, particularly about race, class, gender, age, etc., so that they can become conscious of their biases, root them out, or at the bare minimum, be able to acknowledge when they are influencing the evaluation process, specifically around how data are collected, analyzed, interpreted, and utilized. I can't stress enough how important it is to have consciousness around how you view evaluation, how you conduct evaluations, and how you use evaluations in your work, particularly in areas of criminal justice and court systems. Another step in applying an equity lens in your work is to ask and answer a few preliminary questions that allow you to kind of examine your perceptions and values towards community. Those questions include: how will the way in which the evaluation is conducted honor the cultural context of the community? Will the evaluation improve or potentially make conditions worse for a community? How will the community benefit from the evaluation? By posing those questions to yourself or within your team, if a team is working with a community in an evaluation process, asking those questions and answering those questions are critical to having the kind of clarity you need to make sure that you are not entering a community or entering an evaluation process with a high risk for causing greater harm. The third step, I think, in applying an equity lens in evaluation is to be intentional about seeking opportunities to learn more about equity and be open to being part of learning communities that are promoting, centering equity. One place you can look is the Equitable Evaluation Initiative. It's an excellent example of how a collective of evaluators are working together to sort of redefine and shift the paradigm around how evaluation is delivered, how it brings forth fruit around how to sort of balance the benefits for community and evaluators and or funders of evaluation. The EEI acronym for Equitable Evaluation Initiative is committed to advancing equity in evaluation. It has an equitable evaluation framework that is grounded in three very powerful principles, I think. And it's all about centering evaluation, and it's worth sharing here. The first principle, evaluation and evaluative work should be in service of equity. Principle 2, evaluative work should be designed and implemented commensurate with the values underlying equity work. Third principle, evaluative work can and should answer critical questions about the ways in which historical and structural decisions have contributed to the condition being addressed. It should answer the question around the effect of a strategy on different populations on the underlying systemic drivers of inequity. And it should answer questions about the ways in which cultural context is tangled up in both structural conditions and the change initiative itself. That's just a glimpse or snapshot of those principles. To read more about them and to sort of examine the framework, you simply need to Google Equitable Evaluation and you'll get led to their website. With that coverage of how to apply an equity lens or using an equity lens in evaluation, lastly, I want to speak about equity, diversity, and inclusion as it pertains to data tracking on community courts. And to this point, I also want to offer a few suggestions, if you will. How we collect and analyze and use data is an essential part of evaluations and research. So it's very important to, again, I will emphasize, to be conscious about how you are approaching all of those stages in the process of evaluation. Data collection, data analysis, interpretation, and utilization. So I will refer to my original point about checking biases. So In your data tracking work, I suggest be intentional about acknowledging your biases because they matter and they do influence how you understand and use data. So that is a very important point that I can't emphasize enough. To promote inclusion, one consideration might be to invite members of the community advisory boards that are a part of community court systems. Invite them to partner with evaluators, researchers, court staff, and share decision-making power on what data to track on community courts and how that data is interpreted and used. So consider a partnership between evaluators and members of the community. And then as to this whole point about diversity, let diversity across the spectrum, race, ethnicity, gender, age, experience, etc., be reflected in who is tracking data. So that's speaking mostly to the team of folks who are responsible for tracking data for the community courts or on the community courts. So be diverse in who is collecting data, because all of that diversity can't hurt. And in the data sources access, also be diverse. And what I mean by that is be conscious of not over-relying on any one data source. The tendency is to go to data that is most accessible and or available. And that is necessary. However, it can also run the risk of keeping you trapped in a loop where you're just sort of looking at the same data, saying the same thing. And there's a saying, you know, if bad data goes in, bad data is coming out. And if you're in a loop of using data that's not really good data, that only contributes to the problem and is not allowing you to do your best work. So I would encourage you to think about these suggestions when you are in the business of data tracking, data collecting, data analyzing, and data usage. This concludes my sharing. I appreciate your listening and hope something I've said proves useful. Peace.
Well, hello everyone. That was such an exceptional array of panelists. I know you would all agree with me, and I have to give credit to our hosts and conference planners for putting together such a complimentary group of speakers. When I look at the contributions of each of the three panelists, there's so many themes that align with the goals of conducting inclusive research, ensuring that research processes are such that we can identify not just the impacts, but the implementation fidelity, approaching research through an equity lens. All of those themes that represent priorities for me as NIJ director were also key takeaway points from each of our panelists. So I'm very interested in talking with you more. I understand there might be some questions that have been posted. So the question is to ask for a little bit more explanation on process evaluation and outcome evaluations as they relate specifically to community court implementation. Now, I will be the first to admit, I have conducted a lot of research on a lot of different types of programs and practices, but community courts is not in my area of expertise. So I can answer this question generically, but not specifically. One of the speakers, Matthew Willis, talked about the importance of developing logic models in the course of understanding community court operations and impacts. And I could not agree with him more. Logic models force you to really think carefully about what the inputs are, what are the changes, what are the facets of the program that you're implementing, and what do you expect will happen from each one of those components. So, one component could be identifying eligible clientele, another could be conducting a thorough needs assessment, another could be offering services that align with people's needs, and yet another could be tracking whether there's been take up of those services or whether the clients have not done so. So logic models track all of the various program components in terms of the intended outcomes. And what they do is help you identify what you should be measuring along the way. So that enables us to see, are we identifying the right population? Are we delivering the right services that align with their needs? And so forth. And so that all of that evaluation um, enables you to understand program fidelity, which of course is essential to learning whether the impacts that you see are related to the program and its delivery. Are there any other questions or have we run out of time? Okay, looks like we can wrap up now. So thanks again. I really appreciate the opportunity. This has been a fantastic panel and a terrific conference, and I really appreciate the opportunity. Thank you very much.